But it is kind of our first lecture where we are getting out of kind of the introductory materials of the course, introducing you to the Supreme Court and the judicial system, and more getting into a specific area of the Constitution. So kind of the way that this course is laid out is that after the initial parts about learning about the court, learning about the justices, we're kind of split up into three groups of material. So one thing is with this course, so we have three kind of constitutional law courses here at UB, 301, 302, 303. For this course, this unfortunately is one where we have to use two books. So we have two books between the three classes. So, one of them, it turns out, is going to be one that requires two books. But just to let you know, is that I teach all three of these courses, not every semester. Professor Hinkle teaches Political Science 302 and 303 in addition to me. Professor Hinkle and I coordinate our books. So what I'm trying to say is that if you're taking this course right now and in the future you're going to take Political Science 302, that would mean that the Rights, Liberty, and Justice book, you could use that for that course. If you're taking Political Science 303, which some of you may be doing in maybe the upcoming session, or 302, I mean, it just kind of depends on when they fall, is that you can use these books again. So it's not one that you're buying that you can't use for other purposes later. So one thing that I want to try to show and we're going to see this in all kind of facets of this course, and you would see it in several other constitutional law courses. So this kind of first section of materials, the contract clause, substantive due process, sometimes procedural substantive due process, it's kind of, or economic substantive due process, which is what will come up after chapter 9. And then in chapter 11, the takings clause. What we will see also that when we get to the right to privacy and then the chapters on civil rights and voting rights is that we see that these provisions have a lot of twists and turns. And what I mean by that is that depending on the makeup of the court, you sometimes see rights that are protected a lot more. Sometimes rights are protected a lot less. It's one of those things where it just does kind of depend on the makeup of the court. So, one thing that, you probably would notice was in the news not that long ago was that the Supreme Court decided that there's no longer a right to an abortion in the Constitution. It was not some great new knowledge of constitutional law that led to that. What led to that was that former President Trump got 3 justices on the Supreme Court. And what I hope that you see in this is that often the political interests of, let's say, the president appointing justices, if that president has certain thoughts and philosophies, that can have an effect, that often will have an effect if that president is trying to get people on the Supreme Court that share his philosophy. And we'll see that today in different ways. So kind of keep that as a theme in each of our chapters. So the framers and the contract clause. Now, one thing is that, some have, criticized the founding fathers as trying to think of the way I'm going to put this, as being kind of more self-interested. Because remember, the founders, by and large, were more the aristocracy, if you will. George Washington, great guy in a lot of ways. He was also considered the wealthiest man in the country at the time. You know, he was a large landowner, also a large slave owner. But what you saw is that, you know, the founders were largely people of means. And one thing is that you might have to worry about is that if you're somebody of means, often you are going to be a creditor. So there are often a lot more debtors than creditors. And if you have a lot more, let's say, small farmers, small business people and things, or maybe people that just owe money, one thing that folks were having to worry about, and you were seeing this during the period of time during the Articles of Confederation. So remember that our current Constitution is our second Constitution. The Articles of Confederation were our first. It didn't go over that well. So there were a lot of problems that led to our current Constitution. So if I were teaching this class in person, I usually give out a pocket Constitution. If you want a pocket Constitution, stop by my office sometime, because I have Congressman Higgins provides. All I have to do is ask, and it gives me some free constitutions that I pass out to the class. But where do we see the provision about the contract clause? So, you know, I think that some people, you know, often just think when they hear the Constitution, they think, oh, yeah, like the Bill of Rights and stuff. Well, there's the first 7 articles that come before the amendments to the Constitution. So in Article 1, Section 10, one of the things that it is, so, you know, this is a chapter that also, you know, if let's say we were doing this just in 2 courses instead of 3, this would be one that goes with governmental powers, because what this is in Article 1, Section 10 is the limitation of power on states. So saying that things that states cannot do. Now, Article 1, Section 8 is far more important because it's what Congress can do. So, you know, one of the questions always that you have is that, okay, well, let's say Article 1, Section 10 doesn't say that states can't do it, but Article 1, Section 8, or Article 1, Section 10 doesn't mention states, the power that we're talking about, but Section 8 gives it to Congress. Now, that's kind of more an open question. You know, there's something that we know as preemption doctrine. But when you literally have Article 1, Section 8 says, no state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver a tender in payment of debts, pass any attainder ex post facto law, or law impairing the obligation of contracts, nor shall grant any title of nobility. So there's a lot of things built into that. So the state of New York, for instance, could not make, let's say, former Governor Cuomo, Sir Andrew Cuomo. Nor do I think they probably were thinking about it. But they couldn't do it, because it literally says there. But the important part for us is this. Impairing the obligation of contracts. So if you're going to law school, which often folks that are taking these courses, not everybody is by any means, but a lot of people either are or are thinking about going to law school. In your first semester or your first year, depending on where you're at, you'll take a course called contracts. So what is a contract? So if you look at Black's Law Dictionary, what it says, an agreement upon sufficient consideration to do or not do a particular thing. Now, the thing to remember is that we enter into contracts a lot of times without even thinking about it. So, I have an iPhone. Some folks, maybe you have a different type of phone or something. But, very similar. How often do you have where, it's like, your iPhone needs to update tonight with this big new update. And then the thing is, after you have to scroll down and agree to all these terms. You agree to all kinds of stuff. Let's say if you enter a lease to lease an apartment, or if you're having a mortgage. In a lot of ways, technically, whenever you're using your credit card, it's a contract because you've kind of made a contract that, I'll pay this. But different contracts can be much more involved. Now, what this was doing is that period of time before our current Constitution was in place, that a lot of creditors had gotten burned on, is that there was a time when the country was a lot more agrarian, not as many people in cities. And you often would have a lot of maybe smaller farmers would get together and elect people to state legislatures at the time that would sometimes try to erase debts. So the way that you can, if you have debts, other than student loans, basically, because it's the one thing that basically can't be canceled in bankruptcy court, very easily, I should say, is that at a certain point, people have the option or opportunity to declare bankruptcy. That basically you owe way too much money and you don't really have the ability to pay it off. Now, there's a lot more to bankruptcy than that. That's a course you could take in law school. It's usually not a required one, though. I didn't take it in law school. But, it's probably a helpful one because bankruptcy attorneys can make a lot of money. I mean, it kind of sounds a little bit kind of paradox a little bit. You're going to make a lot of money as a lawyer representing somebody that's declaring bankruptcy. Well, yeah, turns out you can. Because, you're going to, if you're the person that is declaring bankruptcy, you're going to get a good benefit from it. It's not like in every instance, you owe, let's say, $250,000 to various people that all of it will be discharged. Often there might be a payment plan or part of it gets discharged or different things. But states were passing laws at this time that would erase a lot of debts. So making state bankruptcy courts very pro-debtor versus pro-creditor. So, if you're interested in things about bankruptcy, about, how, let's say, laws have been tightened to help creditors by Congress. So kind of it's one of those things where, because of our campaign finance system and contributions and things, we've seen where bankruptcy laws have been tightened to help creditors. Senator Elizabeth Warren has written a lot of things about this. One of the people that helped to tighten a lot of the bankruptcy laws when he was in the Senate was Joe Biden, representing Delaware, which the thing is, if you ever get a credit card or a credit card application, and you probably think, why the hell does it keep coming from Wilmington, Delaware? Well, Delaware has some very favorable corporate laws. So that's why a lot of corporations are chartered in the state of Delaware. You're seeing other states have kind of tried to do similar things like South Dakota. But the one thing is Wilmington kind of has an advantageous location. It's halfway between Washington and New York, right outside of Philadelphia. So, a good spot. So this only applied to states. So remember, Article 1, Section 10 is a limitation on states, not the federal government. That's why we have no state bankruptcy courts. Often whenever I'm teaching this in person, I tell that to folks. I'm like, have you ever heard of a bankruptcy court? Yeah. And I was like, well, where do you have to go? And people just kind of think about it like a bankruptcy court. And I'm kind of like, well, where would you go? And eventually people like the federal courthouse. I said, did you ever hear anybody go to a state bankruptcy court? And then people are kind of like, it's a good point. I didn't really even think about that. So what would happen is that, when a party control would change, states might try to change or cancel contracts. Now, the 14th Amendment makes this provision a little bit less important. And of course, the one thing is that after the Marshall Court, things start going, the contract clause gets different interpretation. So Chief Justice John Marshall, probably our greatest Chief Justice in history, was a champion of this provision. So not allowing states to break contracts and private property was a natural right. So I think one of the things that you're going to see in Fletcher versus Peck, and then in the Trustees of Dartmouth College versus Woodward, versus, let's say, when we get into the Taney Court, is this. These decisions are very good for certain very privileged people. And what often you're seeing that the Marshall Court is doing is putting the public good over a contract, making it where it's going to be very difficult to do a lot of things. Just think about this. When we get to there's a bridge case, let's say, you granted a monopoly, you granted one company the ability to collect tolls going across a bridge. Well, let's say you need a new bridge. Kind of the Marshall Court would say, no, you have to compensate that other person. So, Fletcher versus Peck. This is a case that I think we would say stinks to high heaven. The whole thing stinks. Because there was a lot of fraud, bribery. Basically, this is one of those things where a lot of people should have went to jail. Prison. A lot of things. So, one thing is that when the United States declares independence, we had 13 colonies. But the border of the United States went all the way to the Mississippi River, with the exception of Florida to the south, is what we know. So there was land that is today Alabama, Mississippi, most of Alabama, Mississippi, other than the Gulf Coast counties. Tennessee and Kentucky, Ohio, Indiana, Illinois, Wisconsin, Michigan, and a little bit of Minnesota. Those were areas that were territories. Each state, or most states, claimed some of that territory. Now, Vermont was not a state either, and Maine was part of Massachusetts, just to kind of clarify for you there. These different states claimed that land. So eventually, one of the compromises of the Constitution is that no, different states, you don't get this land. Eventually, we're going to set up a process where these areas will become their own states. So Congress will pass an enabling bill after they get so many people, and they will be granted statehood. Otherwise, one of the problems, of course, would be is, okay, Georgia claims this land, but also North and South Carolina do. So how do you settle that? Do you eventually get where the different states might get to the point where they might want to fight a war over some of this additional territory within the country? So there's a problem. So what Georgia did is that Georgia sold 35 million acres at very low prices, Yazoo lands. Basically land that they really shouldn't have been able to do. So it takes a while to kind of get this compromise and there's different things about this new territory, because even with the ability to create new states, these existing states were still claiming a lot of that land. So this was known as the Yazoo lands. Large parts of Alabama and Mississippi today. So a lot of prominent leaders supported it because they had a stake in it. So they were going to make a ton of money off of it. I think that if you're, if you're sitting there maybe scratching your head and thinking, oh, what's a good word for that? Corruption. Very much. So Georgia tries to rescind the sale and get the land back. So 1796 by a new state legislature, because they could see what had happened. But what happened is that a lot of land companies had already sold off a lot of the land. So, Georgia says, yeah, this is our land. This is our land. And we're going to sell it off and make some money. Our legislators are going to make some money. Some of them are going to be the ones that buy it. So eventually, one of the things that happen is that different tracts of land are going to change hands. So President Jefferson, whenever he gets in office, finally works out some type of a compromise. So by this time, in 1810, Alabama and Mississippi were still territories. They would not become states until 1817 with Mississippi and 1819 in Alabama. And they wouldn't get their Gulf Coast part until the United States eventually buys Florida and then gives them some of the Florida territory. It was known as part of West Florida, whose capital was in Pensacola, in order to give them coastline. So, one thing is that if you would have just drawn the border of Alabama along that river there, which is, I think, the Alabama River. No, wait a second. I don't think it is the Alabama. It's a different river. I can't remember what the name of the river is. It separates Alabama and Georgia down there. If you would have just drawn that south and given Alabama that territory just below, the 2000 presidential election, which we will talk about at the end of the semester in session, would have had a different result because those counties are very heavily Republican. So, one thing that we'll talk about later in the semester, of course, is gerrymandering. I just always kind of ask people, are some of the borders of our states gerrymandered at one point? Now, can't really change them because of different provisions in the Constitution very easily, because you can't really get where a different state takes a bite out of another one. Now, there are occasionally some things where some territories are swapped here and there. I mean, there was something like about 10 or 20 years ago, it was like a tiny town in Nevada went over to Utah or something like that. But it was where both states were on board. It was just a very small area. Now, one thing is that this case was orchestrated to get a favorable decision. So what this was is John Peck buys 600,000 acres from James Gunn, who was one of the original buyers. And Peck sells 15,000 acres to a land speculator named Robert Fletcher. So it was basically a way to try to test the constitutionality of the repeal statute because they would both profit from it. So because they thought that, it would come out in their favor. But, it kind of ends up being, a question of... I'm trying to think of the word that I want to use. A question of, meaning of the contract clause. So the question is, could this be a contract and is it invalidated by the state of Georgia? So for Georgia, so basically Fletcher wanted to uphold the Georgia law. So there's Georgia, peach. They actually produced more peaches in South Carolina, but Georgia's still known as the peach state. It could also maybe be the Vidalia onion state. The name Vidalia onion, by the way, owned by the Georgia Department of Agriculture. So what they said is Georgia couldn't even sell these lands in the first place. These lands were not attached to the colonies. They belonged to the United States or the Indians. States did not have the ability to do this. He also said that fraud and bribery influenced passage here. Therefore, this nullifies the sale. So finally, says that the legislature had the power to rescind this, the subsequent ownership of the land. Now, Peck says no. Georgia could sell the land in question. And even if the passage was influenced by bribery or corruption, even if it's the worst corruption, the law's still valid and the judiciary can't ignore it. So here's one of the big ones now. Georgia is forbidden to pass any law impairing contracts. A grant of a contract once executed can't be revoked. So he said also, the parties here were innocent of fraud. So, they purchased the land. They could not be affected by the fraud itself. Just a lot of people were involved here in buying some of this land, and not just people down the South. John Quincy Adams, Joseph Story. A number of people. So there was a lot of potential gain for some people. What you had was a unanimous decision by Chief Justice Marshall. It was a 5-0 decision. There was a concurring opinion that's not printed by Justice Johnson, and 2 justices did not participate. I do not know why. I don't know if they had a conflict. Maybe they could have made money off of this. So what he's saying here is that the parties before the court today were not infected by the initial fraud in the sales. So the original purpose in sale couldn't be undone due to fraud. So the original purpose could, but not to third parties. So he's saying that, once things started getting passed on between new parties, that the third party, that the subsequent people that owned the land, they weren't involved. So there was valid consideration, making this a contract. So what he says could happen is that if you undo this could essentially become an ex post facto law. So basically trying to create a law punishing somebody for something that they had already done. So one thing that's important about an ex post facto law is that you have to be on notice of what the law is in order to violate the law. So it's punishing somebody for an act that was not punishable when it was committed. So you're punishing somebody for something that was legal at the time that it occurred. So the contract can't be invalidated, even if it was originally corrupt. So Georgia's legislature didn't have the power to invalidate the previously passed binding agreement. So, he mentions things like the bills of attainder, the prohibitions of bills of attainder, ex post facto laws, and obligation of contract. So kind of putting them all together, which the thing is it okay to put them together? Sure. Because one of the things is they are listed together in Article 1, Section 10 of the Constitution. So, Chief Justice Marshall, very, very protective of contracts. So, kind of what his closing here is. It is then the unanimous opinion of the court that in this case, the estate having passed into hands of a purchaser for a valuable consideration without notice, the state of Georgia was restrained either by general principles which are common to our free institutions or by particular provisions of the Constitution of the United States from passing a law whereby the estate of the plaintiff in the premises so purchased could be constitutionally and legally impaired and rendered null and void. So what Marshall is saying, the problem that Georgia did is that it was not just repealing a law, it was voiding a contract, thus violating Article 1, Section 10 of the Constitution. So how does this, Congress eventually has to appropriate a lot of money to clean this up. $5 million. That's a lot of money. Just to let you know, I think the Louisiana Purchase was $3 million. The Louisiana Purchase was in 1803, and this appropriation was in 1814. That's still a lot of money. So it took more money. I'm not sure. You have to account for 11 years of inflation, but there wasn't that much inflation. So just think about that. Because of all this corruption, the taxpayers of all the country had to pay to settle claims for a corrupt plan. And the only way that Mississippi was going to become a state in 1817 is to get these claims resolved. Now, we have some other cases where you see contract provisions also being interpreted. In New Jersey versus Wilson, tribe of Indians gets title to land with a tax-exempt provision, and then they sell the land, and the state tries to tax it. So what the court said there, so, this goes back to, 1858, before the United States was the United States, when basically the country was still British North America, a colony of Britain. So basically they say that the tax exemption stays with the land. And the thing is, if you have land that is tax exempt, that makes your land much more valuable because you don't have to pay property taxes on it every year. I mean, wouldn't we like to have land with no property taxes here? I mean, I think that would be very nice because, of course, we have some property taxes that are quite high in New York. Not the highest, but pretty high. More than states that, let's say, don't have property taxes. So then in Sturgis versus Crowningshield, what you saw is that states could, in a limited ability, have bankruptcy laws. But they still couldn't invalidate a contract. So, limited, but, not very broad, like the federal government. That, I believe, is Daniel Webster. Or is it John Wheelock? Yeah, I think it is Daniel Webster. It really is. Trust me. Daniel Webster, at the time, considered one of the best, if not the best lawyer in America. So this is looking at corporate charters. So one thing about this case is that it goes back a pretty good distance. Like before the United States was the United States. Back to King George III. The mad king that didn't want to grant the United States independence until he defeated them at the Battle of Yorktown with the help of our French allies. So he gives a corporate charter to Dartmouth College, a very good college today in the state of New Hampshire. So it has a self-perpetuating board. So basically what a self-perpetuating board means is that whenever there's a vacancy, basically the board fills it itself, rather than having some outside entity appointing the board. So what that means is that, you can, you're probably, if you have pretty good cohesion amongst, the folks on a board, pretty good cohesion, they will appoint people that are like-minded. So the president at the time was John Wheelock. So he made alliances with the Jeffersonians to get but the one thing is that maybe some people on the board maybe have different ideas. So, you can maybe try to get similar people, but people might drift away over time. So he made some alliances with the Jeffersonian Republicans and got a radical change of the board approved. It basically kind of made the old board powerless. So one thing that it would do is that it was going to make the college, instead of Dartmouth College, it would be Dartmouth University. It would be a public institution. Now, this did not go over that well. There was a great amount of chaos. So the students and the faculty remained loyal to the old trustees, the old board, but the state basically tried to take the place over, which kind of put the college at the brink of collapse financially. So the old trustees hired Daniel Webster, who had graduated from Dartmouth in 1801, and paid him $1,000. So they sued the new secretary of the college, William Woodward, and Webster lost in state courts and then appealed to the U.S. Supreme Court. So Webster argued this case for more than 4 hours before the justices. Very emotional, even tears. He said, "It is, sir, as I have said, a small college, and yet there are those that love it." So, while he made a great argument, it took him over a year to decide the case, so not done at lightning speed. And by this time, both John Wheelock and William Woodward had died. So remember, people didn't live quite as long back then. So for the trustees that wanted to invalidate this, so they said here that this grant here was, 12 trustees, they were given the power to fill their own vacancies in perpetuity. So the changes made by the legislature are not binding unless that old board, as we kind of know it, approves it, and they didn't. So what you have here is that you're basically taking property rights from one group to another. So the old Dartmouth Corporation to a new one, the Dartmouth University Corporation. And what this has the effect of doing is violating the contract clause, so an impairment of contracts. So what they're saying here is that this original charter from King George III is a contract, and essentially you're trying to undo the contract. So for Woodward, who I did not have a picture of, said it was for the public charter was for a public purpose. And it's not the kind of private agreement that the contract clause sought to protect. And that, the parties here to the contract are really King George and Eleazar Wheelock, who I believe would be the father of John Wheelock. So one thing is that, I'm going to look up here. One thing about, those folks is that, they're not the parties. Now, turns out George III was still alive at this time, but, it's kind of like, he's the party. So they're also saying here, the addition of the new trustees did not affect the old ones. Now, one thing is, I think that's kind of a little bit of a specious argument, because, if let's say you have a lot of new trustees that overwhelm the voting power of the old trustees, there's a problem. So they also said, there was also this thing called the American Revolution that took powers of the British government and devolved them to states. So the state has the same powers over public institutions as the king. Now, it's a 5-1 decision. We have concurring opinions from Justices Story and Washington. The dissenting opinion, or a dissent, I think it was a dissent without an opinion from Justice Duval. So what the court says here is that this qualifies as a contract between private parties. So the New Hampshire legislature had no place to try to change this charter. So the fact that the government put forward this charter does not have the ability to transform the college into a public institution. So contracts involving private citizens, not their relations. So between the government. So the term contract referred, he says here, to transactions involving individual property rights, not the political relations between the government and its citizens. So this is a pretty ringing endorsement of pretty strong enforcement of the contract clause, and to say that we're going to count this as a contract. So we're not going to give the New Hampshire legislature the ability to undo this. So one thing is this, is that one thing about people. So you may have often heard the term that there are two things certain in life, death and taxes. Well, it turns out that that is, maybe you can get out of taxes. And, our former president seems to have been pretty good at trying to get out of paying taxes. But one thing is that while some people, they live a long time, don't live forever. The longest, the oldest person, now he was retired for several years afterwards, but the oldest person, the person that lived the longest that ever served on the U.S. Supreme Court was John Paul Stevens, who lived to the age of 99. He retired at the age of 90, which I believe was the oldest person ever on the court. It's a long time. But one of the things that does mean is that there is some end to your longevity. Because Chief Justice Marshall was the Chief Justice for a long time. And that long time was until 1835. So he was the Chief Justice for 34 years. Now, it was kind of his appointment, it was part of the midnight appointments. Something that we don't talk about as much during this course. But John Adams basically makes these appointments while the Federalists still have control of the Senate, and because the new Congress didn't take office until, the new Congress now takes office January the 3rd. Unless it falls on a weekend or so. Back then, it was actually after the inauguration of the president, which the inauguration of the president actually used to be in March? March. So, they were basically, what I'm trying to say is that there was a longer transition, and what John Adams did is makes all these appointments and, creates judgeships, justices of the peace. I mean, they just went hog wild, if you will. And one of his last ones was that the Chief Justice resigned and he replaced him with John Marshall. So this was also the last time that the Federalists controlled the White House. And I believe the last time they controlled Congress. So the Federalist Party basically dies out in kind of I think you would say probably after the 1816 election. So, you no longer have the Federalists. I mean, there were still people that held Federalist ideas. I think you would have to say John Quincy Adams, even though if you were to look in the book, in a textbook, and it would say Party Democratic Republican, or he was much more of a Federalist like his father. But you had kind of something that we see with the Supreme Court. And that is, when you have lifetime tenure, even though a president may have passed on a while ago, or political winds may have changed, and we'll see this big time in the next chapter during President Franklin Roosevelt's first term, those members of the Supreme Court and what you might consider backwards ideas live on. but not forever. Because remember, eventually you're going to have vacancies. So Franklin Roosevelt had to wait 4 years. Then he started getting a lot of them. And it became definitely the Roosevelt Court. But eventually it happens. So Chief Justice Marshall dies. And at the time that he dies, you have somebody that is the absolute polar opposite of him in the White House. And that was Andrew Jackson. So we know of this period as Jacksonian democracy. Jackson tended to represent the interests more of small farmers and folks outside the money centers of the Northeast and the East Coast. So, Jackson was not, let's say, the fan of the giant, plantation owners. Even though he was a slave owner himself and supported slavery, but he was more interested in people that lived more in what we called the West. And I'm not thinking of California, because California wasn't a country at that time. I'm kind of referring to people that lived, to the west of the Appalachian Mountains, in a lot of these new states that had came about. So, for instance, if you were to look at the electoral map when he got elected in 1828 and then re-elected in 1832, now, not every state still used a statewide popular vote, but you would see that some of his strongest states would be states like Alabama, Mississippi, Tennessee, Kentucky, Louisiana. Some of those places like Massachusetts, he did not do well in. So Jackson also favored the public good over restrictive contracts. So this period of time was when I think Jackson would say, if he were here, that he represented more the interest of the little guy over big business and the moneyed elite on the big cities on the East Coast. He was also a big believer in states' rights. So he appoints several justices to the Supreme Court. Now, one of his appointments, so you had the new Whig Party was at times in control of the Senate. So it was to the point where he actually was censured for taking money out of the National Bank. But if you were to come up with somebody that was Jackson's alter ego politically more than anybody, it was Roger Brooke Taney, who, interestingly enough, his bust in the U.S. Capitol is going to be removed and replaced by Thurgood Marshall, because one case that we'll read later in the semester was where the Roger Taney says that people of African ancestry were never intended to ever become citizens of the United States. So, maybe he's not somebody that we want to particularly honor for the Dred Scott opinion. So he held 3 cabinet positions. He was the one that, when Jackson removed the money from the National Bank, wrote the veto message. So very close to Jackson. So Jackson was somebody that was had a bad temper and, would fire a lot of members of his cabinet. And Taney held a lot of those jobs, including Attorney General, Secretary of the Treasury. He was originally appointed as Associate Justice, but it didn't go through. And then Marshall dies, and he gets that. So he becomes the new Chief Justice. Now, we know that Marshall held that job for 34 years. Now, Taney won't hold it as long, but he will be the Chief Justice, and he will hold that job until 1864. So he was from Maryland. He's actually the first Roman Catholic to ever be on the Supreme Court. But he did not, he didn't jump ship whenever the South seceded. So some members of the court did. So what we have kind of out of this are a couple of cases. And we'll see that this is kind of the one really where where the Tawney Court really starts putting his imprint on the court. So 2 bridges. So bridges in the Boston area. So an area known for both bad drivers and bad traffic. So the proprietors of the Charles River Bridge versus the proprietors of the Warren Bridge. Because let's think about this, is that if you have a bridge and it has a toll, and that there's a private party that's collecting the toll, if you build a new bridge, that's naturally going to take money away from the other bridge that's collecting the toll money. The other bridge isn't going to like that. But Jackson was president for 8 years, and it turns out that he appoints a lot of members to the court. I believe that the court actually also expands in size. So, another way. So, remember, 9 is not a finite number. It could be, you could pick any number you want. You could pick 50. Maybe 51, so you don't have a tie. But the original Supreme Court had 6 members. It had once 10. Moved back to 9 because somebody eventually figured out that maybe not good to have an even number because you'd have a tie. So this case actually lasted a while. It lasted 6 years, from 1831 to 1837. So Jackson was trying to be the man of the people, ordinary interest over the money class. So Massachusetts creates the Charles River Bridge Company to build a bridge connecting Boston to Charlestown. You might remember the movie The Town, because there are a lot of bank robbers, I guess, there. They collect the toll money. One thing is that if you're the only bridge that goes across the river between these 2 places, you're going to make a lot of money. Because if you don't have another bridge, your choices are basically, unless you're able to walk on water, and I don't think anybody since Jesus has been able to do that too well. Your choices are, basically some type of a ferry or to swim. One thing is about the Boston area is that it's not warm, and I'm sure the river would be cold, and I'm not sure if it would even be safe to try to swim across. So paying the toll, it turns out, is your best way to be able to get across. But the area grew. It meant a lot of traffic congestion. So they decided to build a bridge right next to the other one. It'd be tolled for 6 years, then transferred the state to be free. So that's basically the way that a lot of tolls are supposed to work. Don't tell the Thruway Authority. But often the way tolls are supposed to be is that something's tolled for a while. So basically that, you don't have the money to pay for something immediately. So it's almost kind of like a mortgage almost. So, money is borrowed through a bond, and the toll money is used to pay off the bond. Now, of course, the way our Thruway Authority is that they use it for maintenance and other things. So it's still on there, and it keeps going up. So the Charles River Bridge Company opposed the construction, said that they had the exclusive right to operate a bridge here, and that because of the contract clause, building a second bridge would violate this because it would hurt their profits. Because, just think about this. You're going to eventually get where the new bridge, which I'm sure is probably going to be a bigger, nicer bridge, hopefully, is going to be free. So if you have 2 bridges that are right beside each other. So imagine if we create I-92 and it would run parallel, just right next to the Thruway. And it's a newer highway. It's going to have the same exits. It's basically going to have everything except it's going to be free. Probably a lot less people would use the Thruway. Now, you might still use a Thruway because maybe so many people are on the new free road. But there you go. So the question here is, did the granting of the charter to build the second bridge interfere with the charter for the initial first owners? So for the Charles River Bridge folks, what they say here is that granting a new company the ability to build and operate a new bridge implies the state will not take actions that create injurious competition from that enterprise. So the law authorizing the new bridge violates the contract clause. So, they mention this. So when the bridge was built, there was a ferry system that was operated by Harvard that made toll money to go across. And they were given compensation. So basically they're saying, okay, if you're going to build this bridge, we don't even think you should build it, but if you do, we have to be compensated for our loss. So whenever in doubt, interpretation strongly against the grantor. So for the Warren Bridge, so there's a picture of it I found somewhere. Nothing in the Harvard Ferry or the Charles River Bridge Company gives an exclusive right to transportation across the river. So when you're interpreting a public grant, nothing should pass just by implication. So the state can't contract away its ability for the well-being of society and their security. So the state always retains the power to provide more transportation for people. So basically what they're saying is that this contract, the only thing it gave the right to do to the Charles River Bridge Company was to operate that bridge, collect the toll, and nothing more. That's it. Anything around it, if you build something new, that isn't covered. Now, what we have here is a 5-2 decision. So the court now has 7 members, you can see. So you have a concurring opinion by Justice McLean, but you have 2 justices in dissent, one of them being Justice Story, who is still on the court. So you can remember back in our previous case, seemed to be a pretty strong, I didn't put in his concurring opinion in my lecture notes here, but, pretty strong supporter, it seems, of the contract clause. But now there's a change in the court. So the object and end of all government is to promote the happiness and prosperity of the community when it is established. So he says it would be wrong that the state gave up the ability for new improvements forever. I mean, you just think about it. I mean, cities on the East Coast were some of the fastest growing in the country. You're having lots of new people moving in. Lots of new people. The thing is, when you have lots of new people moving into an area, you can't just stack them all on top of each other. Maybe you can in Manhattan. But this is before, you had a lot of, really big, tall buildings. What naturally people are going to tend to do is that in order to find places to live and such, they're going to move further out. And often cities are built around sources of water or where you're going to have ports. You have to get across them. So while you have to safeguard private property, you can't forget the community has the right and happiness of every citizen. It depends on faithful preservation of that right. So what Chief Justice Taney says is that there was no exclusivity in this contract. That in order to show exclusivity, it actually has to be very explicit. So he said that, we're having new roads, turnpikes, railroads displacing the old ones all the time. Or, basically maybe making them obsolete. So he said here that new improvements still stand to these contracts. So a ruling here for the Charles River Bridge Company would affect transportation negatively everywhere in the country. Because if I have a financial interest in a road or a bridge or a railroad or something, I'm always going to object to the new one being built unless I get money for it. Well, the thing is, I could provide compensation, but that starts to get really expensive. So, do you all of a sudden have to, let's say, pay twice as much to get half as much? We don't want that. So, kind of a few things here. It shows that the men who voted for these laws never imagined that they were forming a contract. And if we maintain that they have made it, it must create by a legal fiction in opposition to the truth and the facts and the obvious intention of the party. We cannot deal thus with the rights reserved to states, and by legal impediments and mere technical revising, take away them any portion that has the power over their internal police and government, which is so necessary to their well-being. So, the reason I read that, in addition, is that this is also showing a very strong support for states' rights. So basically saying, we are not going to let the U.S. Constitution, this provision, the contract clause, basically bar forever your ability as a state to make improvements for the greater good. Now, Justice Story, dissenting here, so he said there was an implied agreement. So to allow another bridge would basically destroy this contract. Now, in some subsequent cases, what we see is that there are, in this period and in the post-Civil War period, cases that weaken the contract clause, but not always. So in West River Bridge versus Dix, the court upholds eminent domain even when it conflicts with existing contracts for the public good. So Bronson versus Kinsey, the court invalidates an Illinois law to expand the right of debtors. So that was not good. Then, this is an interesting one. In Hyde Park, the area of Chicago where Barack Obama used to live. Northwest Fertilizing Company versus Hyde Park. The company was created to convert dead animals into fertilizer. One of the things is that's probably going to stink. It may have some negative health effects too, because I'm sure there weren't a lot of environmental laws in the country at the time, or in the state, or in the local areas. It was a very sparsely populated area, but it later grew around, and the town grew around it, and the town didn't want it anymore. So they passed a public nuisance ordinance that upheld under local police powers. So the state can't contract away their inherent powers to regulate for their citizens' health, safety, and welfare. So one thing here is that the court in this case was in the period of time that we kind of know as the Industrial Revolution Court. So it was a court that was tended to be more pro-corporation and the wealthy. But here, I think they were also saying here, it rests on the fundamental principle that everyone shall use his own as to not wrong and injure another. So kind of what Justice, so that was actually from, so another thing from Justice Noah Swain. The rule of construction in this class of cases is that it must strongly against the corporation. Every reasonable doubt is resolved adversely. Nothing is taken as conceded, but what is in mistakable terms an implication, or by implication equally clear. The affirmation must be shown. Silence is negation, and doubt is fatal to the claim. The doctrine is vital to the public welfare. So one of the things that I think this kind of means is that it has to be pretty darn clear that in a contract. But then I think that's what we kind of got from the Bridge case. But what we kind of see in this one is that, even if it's pretty clear, that gets us to Stone versus Mississippi. So one of the things is that gambling is everywhere in the United States now. It really has picked up steam in the last 30 years or so. Where at one time you basically had Nevada and Atlantic City. Now the thing is you can go to Niagara Falls, or I think there's a casino in Buffalo. There's one in the Southern Tier. Go to Canada. You could go to Erie. Needless to say, there's a lot of gambling going on. Not the Constitution, but the Revolutionary War, one of the ways it was paid for, actually, was by a lottery. So gambling's been around for a while, but sometimes what you see is that some forces are trying to stop gambling. So, but one thing is that gambling and lotteries and things make a lot of money for the government. And one thing is that it's some people call it a tax on the poor, but I think that's a little bit of, maybe poor people, maybe they're trying to say gamble or play the lotteries more. We'll leave that up to that. But nobody makes you buy a lottery ticket. If I buy a New York Lotto ticket at Wegmans, nobody's making me do that at all. But, if I give them that $1, or if I buy Powerball and $2, I am helping to fund state government voluntarily. Now, with, let's say my property taxes, or gas taxes, or sales taxes, or income taxes, that's not negotiable. So the way this worked is that this is the way that sometimes that government will do things. So they'll contract out to some corporation to run something. So, where they'll run it on behalf of the state and they'll get part of the profits. So they pay an initial fee, an annual payment, and a percentage of the receipts. Pretty standard. So then one of the things that happened was that the state of Mississippi passes a constitutional amendment in 1870 providing the enforcement of the anti-lottery provisions. Nor shall any lottery hereto authorized be permitted to be drawn or tickets to be sold. So, one of the things is that this was a period of time where Mississippi, before, they had authorized this lottery, but it kind of dovetails in a little bit with Reconstruction, where every state basically was forced, that was coming into the United States, was forced to redo their state constitutions. That's kind of interesting. So one of the things is the new folks that were elected were kind of like, no lottery. And there was a law doing this too. So the Attorney General of Mississippi, John B. Stone, filed charges against John B. Stone. I don't know who the state attorney general was at the time. And others associated with the Mississippi Agricultural, Educational, and Manufacturing Aid Society for being in violation. So notice that these things are kind of on top of each other. So the lottery is approved in 1867 for this Mississippi Agricultural, Educational, and Manufacturing Aid Society, whose basically only existence was to run the lottery. So the state sought to enforce this, saying that the Constitutional Amendment stripped the contract of enforceability. So basically, who wins is a good way of putting it. And for Stone, here saying that, they had a contract for 25 years. It was fully spelled out, all of the provisions here, and Mississippi following the contract clause. There's a picture of a riverboat casino in Tunica, I believe. So Mississippi has a lot of gambling today, even though it's considered kind of the buckle of the Bible Belt. But actually, Tennessee, I think, is the buckle. But they're the state that is known for being socially conservative, but they have a lot of gambling. It produces a lot of money for the state. It's a poor state in America. So for Mississippi wanting to void the contract, the legislature cannot bind the will of the people. The legislature can't contract away the state's police powers. And basically, one legislature can't bind future legislatures for issues of public health or morals. So, I think what the state of Mississippi is saying, Mississippi giveth, Mississippi can taketh away. There you go. So it's a unanimous decision by Chief Justice Waite. Is 9-0. By this time, we have 9 members of the court. So Mississippi wins. Basically, what he's saying here is that The legislature can't contract away the police powers of a state. It extends to public health and morals. Lotteries can be the subject of morals or evils. So they are therefore subject to state police powers. So basically here, the contracts which the Constitution protects are property rights and not governmental. So basically the state can do this. Kind of there is conclusion here. All that one can get by such a charter is a suspension of certain governmental rights in his favor, subject to withdrawal at will. He has the legal effect to nothing more than a license to enjoy that privilege on the terms named for the specific time, unless it be sooner abrogated by the sovereign power of the state. It is a permit, good as against existing laws, but subject to future legislative and constitutional control or withdrawal. So another thing that I think that you may be kind of noticing here, at least I hope maybe you are, is that this seems to also be bound up a little bit by kind of support for states' rights. So basically saying that state governments have a lot of power. So in our next lecture, what we are going to do is that we're going to finish up this chapter. I can tell you that the next lecture, it covers a little bit less material this time, so we'll take a look at that. So that will finish up chapter 9. So hope everybody stay safe, be well, and I will see you next time for lecture 5.